a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
We got the real good one, and he's much better than me giving legal advice. David Whiting, good morning to you.
Thank you, Virginia.
You could do worse.
Oh, far worse. Far worse. I'll introduce you to some of them if you like.
It's nice to know that there is a baseline even below me that exists. Did we have any homework from last week?
We were homework free. We managed to resolve problems for 9 people last week.
Excellent.
Fantastic.
And any legal news that we need to share with anyone? Anything going on out there?
No, it's all pretty much the same. There's the state government power. You know, the question would be, would you get on a plane and go overseas next week?
No,
who knows?
You really would not. And I know tons of people from here on Talkback and in my life who have booked those flights, and I don't know what they're thinking right now. Oh, I have a friend who's actually just gone to London. He won't make it back for Christmas, will he?
Well, I have a friend who's planning to go to London in 10 days' time, and I'm just thinking, yeah, maybe not.
No, you're nuts.
No.
Okay, but then what's going to happen if let's say you booked a ticket that has restrictions, or you don't actually have a formal order that's been made by the health officer to say you're in lockdown, but you're saying, look, it looks too scary, no order has yet been made, I don't want to go. And they say, well, sorry, we're not obliged to give you a refund under those circumstances.
I think that's right. I think the answer would be you've made a decision about you rather than the government making a decision for you.
Yeah, that's right. So that makes it equally as tricky. All right, well, if you've got something like that, you can ring in. 1300 222 774 is the number. John in Oakley, good morning. What's going on? John, are you there?
John from Oakley.
That's it. You're on the air. Good morning. Go ahead.
Hi. My mother is the sole title holder of the house that she lives in after my father passed away several years ago. And I also live in that house. In fact, I've lived in that house for the whole of my life. The question is, if the house was sold, do I have a claim also to the proceeds of that house or not?
Probably not, John. Have you done anything? Do you pay board? What relationship do you have with your mother in relation to the property?
I'm a carer for her.
And you get paid for that, so there'll be a social security benefit you receive for that, which isn't a lot of money, but at least it's something. My view is that you're unlikely to have any direct claim on the house. Do you have siblings?
No. No siblings, no brothers, no wives, no nothing. It's just the two of us.
So the expectation would be that when your mother dies, the property would pass to you anyway, is what I would expect. And even if it didn't, you would have a very strong moral claim on the basis of the contributions that you'd made and the life that you'd given up for a very lengthy period of time to look after your mum.
Yeah, understood. So, my question was if the house was actually sold before she passed away, and I think you've just answered that.
I think the answer to that question is no, John. Yep.
Thanks, John. Thanks for calling in. I hope that's of any use. Tim in Princess Hill, good morning.
Yeah, morning, Virginia. Morning, David. David, I work in Owners Corporation Management, and we have some amendments to the Owners Corporation Act effective 1st of December.
Tomorrow. Yep.
Included in that, it's introducing 5 tiers of Owners Corp. So Tier 1, more than 100 occupiable lots. Tier 2, 51 to 100. Tier 3, 10 to 50 occupiable lots. Tier 4 and Tier 5. The main thrust is to try to improve quality of Owners Corporation managers, enhance protection for Owners Corps, and expand and improve developers' duties.
Yes.
One of the provisions is a maintenance plan and what I call a sinking fund forecast, having mainly worked in Queensland, returning to Victoria in 2018. I see that as a great change in order to have a sinking fund or maintenance plan.
I think that, look, I see that as a positive. Tim, but what's your question?
Well, I just wanted your thoughts on the legislation. 1 in 4 Victorians live in a strata complex, and what are your thoughts
My view is the problem we've got is that lots of owners' corporations stagger from year to year, and I think that for lots of, certainly the bigger ones, if there was a pot of money that could be used for maintenance, I see that as a positive. The bit that I got out of the legislation that starts tomorrow is that it's now possible to do additional annual charges for owners' corporation members where they receive a benefit that's not commensurate with the unit liability.
So I hope that's of use, and work your way through the legislation. Maybe it's the new version might turn out to be more useful for you. Milton in Docklands, what's going on?
Good morning. Excuse me. Good morning. Yes, I recently purchased a refurbished iPhone 8 on a reputable website. It came as it said that it was as per Apple standards in their refurbishment, and met all Apple requirements, especially in regards to waterproof, being rated to IPA67, maximum depth of 1 metre by 30 minutes, etc., etc.
Yes.
Now,
you tried it out, did you? Was that the problem, Milton?
Did you chuck it over the dock in Docklands, did you?
Not exactly. No, I was walking along the beach and I did drop it in the shallows briefly, so it was at no point exceeded those definitions.
Parameters, yes.
Yes, and now they're refusing to repair it under warranty.
Why?
I'm looking at either that they sold me a defective product because water got in, or they have falsely advertised the specifications of their phone.
Well, I think the answer would be that you certainly have rights under Australian consumer law. There was an express representation as to the amount of time it could be in water and the depth, and it failed that. So you have a claim under Australian consumer law. I would write to them and say, you made this express representation, the phone didn't meet it. I would like the phone replaced, please.
Now, previously, listening to you on a previous occasion, you mentioned it before applying to VCAT, because I've tried numerous letters and emails and backwards and forwards, and they're refusing to do anything.
Yes.
They've come to sell me a cheaper phone at $200, but that I want my money back, preferably.
Yes.
Now, if I go to VCAT, am I required to send them a letter first?
Technically, no. The Civil Procedure Act relates to court proceedings. There's no need for a letter of demand beforehand. So your answer is no, but you might write to them and say, look, thank you, but no thank you. It's my money back, or I'll go to VCAT and get an order for my money back.
Is it worth going to VCAT over this one, David?
Well, what did you pay for the phone, Milton?
$480.
But, I mean, my problem is the queues at VCAT are currently 2 years.
Mm.
So you're going to have to buy a replacement phone in the meantime.
Yeah.
True.
So, and then you go to VCAT and say, well, I couldn't rely on anything they told me because they don't honour their promises.
Well, maybe watch out for those companies that sell the refurbished phones. There's a reason they are drastically reduced from the top one. And look, it's even hard sometimes with the big companies, if you buy them brand new, to even get everything that they seem to indicate in the warranty, right?
Oh, absolutely. But I mean,
that's hard enough.
But Milton's bought an iPhone 8, what's that, 5 years old. But, you know, if they make an express warranty as to its waterproof, then that's what it ought to be. Look, you can make your application to VCAT and see whether that leads to a faster resolution. Good
luck, Milton. Hope that's useful. Sam in Macrae, what's happening there?
Good morning to you both. On that horrible day of weather about 2 weeks ago, the front neighbour of our units, his solar panels blew off, damaging our roof considerably, and he claims that he's not liable. I would have thought that if his property damaged our property, he would have been liable.
Yes. You might also have a go at the installer who... there's a concept called damage caused by an act of God. It was the kind of wind that no one could ever have contemplated. That's fairly hard to prove, so my view would be your neighbour ought to make a claim on his insurance policy. Now, depending upon the way your units are structured, does the roof belong to the unit holder or is it part of common property?
No, it is a separate roof.
So if there are a block of units that each have their own roof, you're like in a row, the general proposition would be that it's the roof of the unit owner above the unit, but under some of the structures you only own to the roof line, to the ceiling line, and above that's common property. I'd find out whether that's the case and maybe look and see whether there's an owner's corporation policy you could look at as well. But if it's part of that owner's unit, it's up to the owner of that unit to prove effectively that it wasn't his fault. So your starting proposition is they were bolted to your roof, they came off your roof, they were installed at your request and direction, it's your problem.
Right, that's what I believe as well, David. Thank you.
Thank you, Sam.
And
Hope that's helpful, Sam. Thank you. And I have a feeling it's not the end of it, because these big wind events, they may or may not be acts of God, but they're definitely more common.
Yes, they're certainly going to get worse.
Do you think there'll be some changes made to insurance policies or to the kind of guarantee you're given after this work is done because of the increasing frequency?
No, I think that insurance policies... I think that the pushback for I'm not going to give you offer protection for strong winds is simply not going to work.
Yeah, it's the reason you get the protection,
yes,
correct?
Absolutely.
Yeah, exactly.
Yep.
Janet in Albert Park, how can we help?
I think we're a Tier 3 body corporate, going on with your earlier caller, and 56 construction last century, was a company share, now is strata. Very much mixed infrastructure right through the place. It's a real nest.
Yes.
We've got cold water galvanised pipes running to most of the apartments, and when they leak, people are making a claim on the OC's insurance.
Have a look at Section 12 of the Subdivision Act, and it relates to what I will call the provision of shared services. I think that the water pipes, certainly for most of their travel through the building, will be owners' corporation issues.
We have a problem with pipes that aren't leaking but are constricted in their diameter because they're cold water galvanised pipes,
yes.
And they're blocking up.
They're filling up
completely.
with gunk, yes.
And that's creating a complete refurb issue. And my position has been, look, if we all claim to get those refurbished, then we're all going to have to put more money into the OC to pay for the refurbishment. So there's no net benefit.
Yep.
Some people are really pushing to say, and it's not just pipes, it's a complete bathroom gut, because you've got to pull the walls apart to get to the pipes. So who owns those cold water pipes that are running down through?
You would need to look, Janet, at the strata plan, and you would need to have a look at Section 12 of the Subdivision Act and Sections 48 and 49 of the Owners Corporation Act. If you think about the water supply that you get from your water company, they own the lines in the street, and while the meter is well inside your property, you are responsible for the bit under the road where your pipe meets their pipe.
We actually have shared meters, and there's only 2 meters for the entire block of 28 apartments. Then
why would you not see if we can also go to the trouble of getting them all separately metered?
There's no separate runs for cold water. They're all shared. There's a couple of big copper runs with tails going off to different apartments.
Then it's a decision. Then it's a decision that, as a collective, you need to make. And if you've got more than 50% of the people who disagree with you, think of it like what happens at election time. You don't always get the answer you want.
Yes, indeed. Is that helpful, Janet?
It gives us some direction. Thank you very, very much.
Fantastic. Good to hear of it. Chris in Yarraville, what's going on there?
Hello. I've got a little garden with some big trees in it, which I love. And my new neighbour, first he wanted to trim the tree that is over his fence. Now, this is a tall tree, like 50 years old.
Yes.
And I said fine, because I believe legally he has the right to trim the tree. Yep. He did that, and then he got back to me and said the tree cutter said the only way to stop trees falling in his gutter was to take pretty much the whole canopy of the tree off.
Yes.
And I said no, and then he wanted to chop the tree down, and I was sort of open to it.
It's slightly worse than the canopy going, isn't it?
It is worse,
yeah,
but I didn't want a 20-foot stump in my backyard.
Yes.
So anyway, I asked the council, and they said, yes, you can chop it down. And by this stage, I decided I really don't want to lose my tree. Now, he's not saying it's damaging his house. He's saying that he would have to get his gutters cleaned. He's already taken like half of the tree off on his side of the fence.
Yes.
And when I said I wanted to keep the tree, he said he'd be happy, but he wants to shave it to the fence. Now, I think that's going to damage the tree. The arborist I tried to hire said they don't get involved with neighbours' disputes, and the council said they don't get involved with neighbours' disputes. Do I have the right to say he has cut as much off my tree as I'm comfortable with? Is he,
Yeah, you
what am I
certainly
right?
have the right to say that he can cut off as much of your tree as you're comfortable with. Now, that
Yeah.
may or may not meet his requirements. Remember, though, Chris, it's your tree and your leaves.
Yeah.
So why would you not simply offer to pay for the gutter cleaning?
Because he suggested that it would cost $200 a month, every month, so it would be cheaper for me to cut down the tree.
$2,500 a year to clean the...
Yeah,
Yeah,
and I don't
Boulder
think that I'm
Dash.
really responsible for cleaning his gutters. Now, this was just a subtle suggestion. I don't know that he really meant that.
Yes.
What do we do here, David?
Well, it depends on how hard your neighbour pushes, Chris, because it is your tree and it is your leaves and they are causing a problem for him.
Okay, so he could actually make me pay for cleaning his gutters.
He could make you come and pick up the leaves, which would be worse, wouldn't it?
But
No,
what
I
if?
think
What,
Russell's
let
around
me
halfway.
just jump in here, Chris. What if Chris organised? I mean, I think that quote is just bonkers.
Yes.
What if Chris got a much lower quote and organised to have it cleaned from time to time?
Well, my view is that it wouldn't be necessary to do monthly.
Oh, no,
you
of course
might
not.
do 2 or 3 times a year.
Yeah.
So
I
that would be
clean
the
mine.
offer that I would put. I'll get an arborist to come and I'll get someone who's appropriately qualified to clean out the gutters 3 times a year. You choose the frequency.
An
I'll pay the
arborist
bill.
isn't going to clean out the gutters.
No, you're right.
Well,
It will be a gardener. Yes.
But maybe the arborist needs to cut some branches as well, Chris.
Well, no, the arborist has. When he hired them, they chopped off maybe 5 metres worth of branches. So it's not touching his house, but there's still overhang. And even if he shaved it to the fence line, he'd still get...
There'll still be some leaves, yeah.
Yes.
No, and Chris, that's your job. It's your tree, your leaves.
Yeah.
So it is my problem to clean up the leaves off his roof.
Yes, it is.
Yeah.
Yep.
Because your tree made them.
Right.
So, but go and get a couple of quotes.
Okay, thanks for that.
Don't get snowed by those quotes because they're sounding a little high, aren't they, David?
It's an ambit claim.
Nothing wrong with an ambit claim. You can always give it a go. Louise in Northcote, you've got a question about the fees that David Whiting's been charging you. Is that right?
I wish. Thank you very much for taking my question. I have an ongoing issue, and my substantive lawyer suggested I contact a specialist lawyer, which I did, and I've been charged $250 for the disclosure statement is my first question. Like, is that a standard thing that they can charge you just to send you that notification?
No.
And-
No.
Sorry?
Here's the way it works. The disclosure statement is supposed to be there's 3 levels of fees. Below $750 plus GST and out-of-pocket expenses, no disclosure requirement. Between $750 and $3,000 plus GST plus disbursements, there is a short form disclosure requirement. Above that, for anything over $3,000, there's a particular... the documents need to be provided as soon as possible and hopefully before the lawyer starts to work for you. Now, my view would be that there is no basis for charging for the preparation of that document. If you don't reach an agreement with the lawyer, then there's no work to be done. Now, sometimes a lawyer will start work for a client and then send the costs agreement, and that happens not all the time, but in fact it happens, in my view, most of the time, because a client comes in and wants certain things done, and you send off the letter to the other side at the same time as you send the letter to the client. But that doesn't bind the client to the costs agreement at that stage. So I would be coming along and I would be strenuously arguing that you have an obligation to pay for him to tell you how he's going to bill you.
Just the last part,
I don't see, if let's say you came to me and you've got a specialist lawyer, that's great. If the lawyer says, I'm going to give you a quote that will tell you not how much I'm going to charge you, but how I'm going to charge you, and I want you to pay for the privilege of me giving it to you, I think that's horribly unreasonable, and I would say thank you, but no thank you.
Okay, so...
Find someone else, you mean?
No, I'd already started... Oh, sorry.
No, you can stop whenever you like. But
Correct.
But I would be objecting to that element of the account. Yes.
Yes, that's all, because I agree with the other parts of the account. And just one other question was that he then phoned my substantive lawyer, and I never instructed him to do that, and I've been charged another $500 for him to phone my substantive lawyer.
How long was the phone call, just out of curiosity? How long was a $500 phone call for your specialist lawyer?
It was a little over an hour.
Oh, okay. All right. Yep.
Yeah,
but I suppose
might have
the
been the
question
kind of
would
phone
be
call
why.
it might have been the kind of phone call that was allowed to go for an hour.
Does that happen, does it?
David, you know that happens. All right, so a bit of a fight here Louise has to have. Is that...
Yeah, I would be coming along. So I'm happy to pay the rest of the bill, but I'm not paying that line item because I think that you're discharging your obligations at law, not to me.
I had to have a fight like that once with a lawyer when I got the bill.
Yes.
It was just a ridiculous sum of money. And I just rang back and I said, I didn't ask you to do that much work. And they went, oh, all right, what do you want to pay? I was like, talk about ambit claim.
There's the process involved in enforcing legal fees are such that you'll get lots of that.
There's lots of leeway.
Yeah, well, no, it's not that there's... The issue is going to be... let's say I do some legal work for you and we have a disagreement on the account. There's a process in relation to taxation of the accounts in the Supreme Court or in the Costs Court. Then we go off to the Magistrates Court. So it could be 2.5 years before I get paid.
Oh, yeah, well, I'm not going to do that. I'm probably just more likely to give in and pay it, but I may grumble about you in the background.
Right, you sure you will?
Yeah. Let's see if we can really, really quickly just deal with Len in Viewbank. What's going on, Len?
Well, thanks for taking my call. My issue is that a tree fell into our backyard a few years ago, and I'm adjacent to a park. There's a whole lot of trees along the fence line. And this particular tree is a big gum, and a branch fell off, and there we were.
So is this a council tree or a Melbourne Water tree?
No, it'd be council.
Yep.
The reserve's owned by the council, the tree's owned by the council.
Yep.
So I
might have to get you to your question pretty quickly here, Len. What's the question?
All right. During that big wind, up to me advising council that this second gum is likely to cause damage. It did.
It did,
right.
and even though you'd warned them that it was likely to.
Yes,
Len, I want to feel comfortable about the obligations that councils have in relation to trees as opposed to Chris in Yarraville and her neighbour. I'll go and have a look and we'll call it homework for next week.
Len, have a listen next week and we'll see what advice we can give you. If you tune in, David will address that at the very top of our discussion. Thanks for calling in. Thanks, and all the best to you. And great to hear from all of you. I hope that was useful. David, you have a lovely week. I'll see you next week.
Indeed. Thank you.
Head off into that beautiful sunshine. David Whiting there, been helping you with some legal problems.